A good day to all of you. Today we will be starting the revision series from the first lesson onwards. According to the lessons, one by one we will be doing the revision series. So altogether there is around 10 lessons. From each lesson the most important areas will be selected for the revision series. It's very important to note that not all areas will be explained in this revision series. Only the most important questions will be discussed in the revision series, most important ones for the exam, together with a focus on the exam questions that this revision series will be carried on under corporate law. So today we will be starting with the first lesson of the revision series under features of a company and corporate personality. This is the revision series. A note has been shared with all of you. I prefer if all of you have a copy of the note so that you can use it, peruse it. Whenever there is something important, you can even highlight it for the exam, because some areas I will be telling you that these areas have been questioned earlier at the exam, and therefore that there's a possibility of it being questioned again. So having the note with you, let's follow through the revision series. We'll be doing a comprehensive past paper discussion later on, but this particular area or this particular set of slides is just to cover up the most important areas of the syllabus one by one, lesson by lesson. So today we are going to start with Unit 1, the features of a company and corporate personality. So under that, the first area that is there in the syllabus is the laws governing companies in Sri Lanka. So when we consider the laws governing companies in Sri Lanka, as of now, the most important law governing companies in Sri Lanka is Companies Act number 7 of 2007. There is no way for you to forget this act and go for the exam. Throughout the lecture series, I'll be focusing again and again on this particular act, because you need to remember the present act that is governing the company matters in Sri Lanka, which is the Companies Act number 7 of 2007. Of course, throughout the lectures or throughout your syllabus, from time to time, different sections of this Companies Act is being used. If you can remember the section numbers, very good. But if due to some reason, if you can't remember the section numbers, it's not going to impact your writing of the answers. You need to know the crux of the act. Sometimes section numbers you might not remember, not a big deal. Nonetheless, the act is very, very important. Act number 7 of 2007. There is no way out without knowing the act. So at the beginning of the lesson itself, how the lesson starts is, what were the laws before that were governing company matters in Sri Lanka, and how the law have changed now to the Companies Act number 7 of 2007. To the Companies Act number 7 of 2007. The current act is Companies Act number 7 of 2007. But previously there were some other Companies Acts which were repealed by this current Companies Act number 7 of 2007. What is the meaning of repealing? The previous act is not there any longer, or we don't use the previous act any longer. Previous act has been removed and a new act is now in place. That is what we call as a repealing of an act. So a previous act has been removed and a new act is now in place for the companies. So the previous acts that were there, they might not question you on this, but of course having a rough idea is important. So previous to this Companies Act number 7 of 2007, we used to have a Companies Act number 17 of 1982 that was also amended by Companies Amendment Act number 33 of 1991. So that is the exact act that was there before the 2007 Companies Act. So before the 2007 Companies Act, we had Companies Act number 17 of 1982, which was amended by Companies Amendment Act number 33 of 1991. These years you don't have to remember, but this 2007 year is very, very important for you to remember. Then before that we had the Companies Special Provisions Law number 19 of 1974. Even before that we had the Foreign Companies Special Provision Law number 9 of 1975. So those were the laws that were there before the Companies Act number 7 of 2007. Nonetheless, the applicable act today is Act number 7 of 2007. You need to have a very good clear idea about Act number 7 of 2007. Now, one question that they could ask you, which has not been asked over the previous years, but a question that could be asked is, what were the changes that were brought about by Companies Act number 7 of 2007? I mean, in relation to the previous Companies Act number 17 of 1982, what are the new things or what are the changes that have been brought about by Companies Act number 7 of 2007 is something that they could ask you. So therefore, let's focus on that as well, as to the changes that were brought about or the features of a company under Act number 7 of 2007. First one, incorporation of a company was made convenient. Now, meaning earlier incorporation of a company was quite a crucial, difficult process. Not anymore, right? At least it has been, made easier than before. At least it has been made easier than before. So previously, to incorporate a company, we also have to submit something called the Memorandum of Association, having the names and the signatures of the initial subscribers or the first shareholders of the company. Now we don't have to submit a Memorandum of Association when you are incorporating a company. You don't have, only the application for registration is important. Memorandum of Association, requirement of the Memorandum of Association have been currently removed. So therefore, that is not there. Incorporation has been made easier. Actually, nowadays, practically speaking, it's even much more easier because now we have the EROC platform, Electronic Registrar of Companies. So very easy to register a company. Those days, if you had to go to the office, the ROC office, Registrar of Companies, the office, now you don't have to go there. Everything is happening online and completely, it's a paperless process now. Everything is happening electronically. So actually now, practically also, it has been made much easier than before. So first one is, incorporation of a company have been made easier than the previous Companies Act. Second one is single shareholder companies, right? So about single shareholder companies, under the previous law, a public company was required to have a minimum of 7 shareholders. Under the previous Companies Act, public companies must have a minimum of 7 shareholders. Private companies were required to have a minimum of 2 shareholders, right? But in the new act, under section 4.2 of the new Companies Act, that is Companies Act number 7 of 2007, a company shall have no less than 2 shareholders, right? A company can have a minimum of, any company can have a minimum of 2 shareholders. You can have single shareholder companies if the single shareholder is the secretary to the treasury holding shares on behalf of the government of Sri Lanka. So usually the requirement earlier was 7 and 2 for public and private companies. Now it has been made a 2 for all, right? So minimum 2 shareholders should be there. So the single shareholder companies, if you are holding shares on behalf of the state of Sri Lanka, the government of Sri Lanka, as the Secretary of State or the Treasurer, then single shareholder companies were also allowed under Companies Act number 7 of 2007. Third one, simplified internal operating procedures. So, permits companies to carry out its affairs with a single director. Earlier, you could not have, especially when it comes to public limited companies, you could not have a single director company. But now it is not so. You can do the operating procedures even with a single director, even in a private company, no problem. Single director can move on with the activities of the company. So, that's another advancement that was brought to the Companies Act of Act number 7 of 2007. Advancement brought about by Companies Act number 7 of 2007. And last but not the least, simplified formal procedures. So even the earlier, for everything, anything to be done in a company, we needed to have a court order or a court procedure. Majorly, the major things like dissolution of a company, major affairs of a company were through court orders. So actually under the Companies Act number 7 of 2007, they dispensed off with this requirement for court orders little by little. I mean, in some situations it is required, but at least not as much as those days. Now, Majority of things company can do on its own without really going to court. So those were the changes that were brought about by Companies Act number 7 of 2007. Incorporation of a company was made convenient. Single shareholder companies were established. Simplified internal operating procedures than before, as well as simplified formal procedures in the operation of a company, in the management of a company, simplified procedures. So not much of a knowledge is required, but some idea if you have, it is good, because there is a possibility of a question being asked from this area. So far have not been questioned much, but of course it can be questioned in the very near future. So having a good idea about that is also important. And after that, the next area is on the features of a company, another important area, because it's an area that can be questioned, have been questioned in the past. When you take a company incorporated under Companies Act number 7 of 2007, what are the features that this company particularly has? First one is the separate personality, right? First one is the having a separate legal personality. What is the meaning of having a separate legal personality? The company is recognized as a separate person, separate from its owners, shareholders, directors and the management, right? So in law, basically we have in law we consider two types of persons, right? In law we consider two types of persons as natural persons and legal persons. We have two types of persons in law called natural persons and legal persons. Natural persons are people like you and me, born out of a mother and father, made out of flesh and blood. We are natural persons. On the other hand, legal persons are mainly company. So this separate legal personality comes through this legal person. So only incorporated companies incorporated will have a legal personality, that is they are recognized separate from its owners, shareholders, directors, management, etc. Company can stand on its own as a separate person. Easy way to remember this, usually natural persons, right? Natural persons like you and me, we usually have a birth certificate, right? Companies on the other hand, being legal persons, have a incorporation certificate. So that is their separate legal person. They are identified as a separate person, right? I'll give you another example for this separate legal personality. I'll give you another example for this separate legal personality, something like this. We will take it in comparison to the, we'll try to take it in comparison to the, we'll try to take it in comparison to the sole proprietorships or sole traderships, partnerships, and then we will come to companies to identify what is this separate legal personality, to identify what is this separate legal personality. Alright, so when we take a sole proprietorship, right, if you take a sole proprietorship, now let's say sole proprietorship, for example, let's think that a person called A, starts a sole proprietorship called A Traders, right, starts a sole proprietorship called, this is the person A, starts a sole proprietorship called A Traders. Let's say, for example, I'm trying to explain to you what is this separate legal personality. You go and buy a chocolate from A Traders, the chocolate is expired. Against whom will you go to court? Will you go to court against the person A, or will you go to court against A Traders? If you go to court against A Traders, for example, let's say you go to court against A Traders, right? If you go to court against A Traders, court will tell you there is no one called A Traders. Why? A sole proprietorship don't have a separate legal personality. There is no person called A Traders. So if you go to court, court will say there is no person called A Traders, thereby you have no case. You have no case, right? So therefore, you will have to go to court against the person A. Why? In a sole proprietorship, there is no In a sole proprietorship, there is no separate legal personality. Owner and the business is one and the same. Owner and the business is one and the same. If you are going to court, you have to go to court against the person. You can't go to court against the business or the sole proprietorship. On the other hand, let's say two people, right? On the other hand, let's say two people, A and B. Now we are talking about partnerships. Two people, A and B. They are people, right? People start a partnership called AB Traders. Starts a partnership called AB Traders. Same way, you buy a chocolate from AB Traders, the chocolate is expired. Against whom will you go to court? If you go to court against AB Traders, court will tell you there is no person called AB Traders. There is no person called AB Traders, no use going to court against AB Traders, right? There is no person called AB Traders, therefore you have to go to court against the persons A and B. You have to go to court against the persons A and B, or A or B. I'll not focus on that, that's a part coming under partnership. Anyway, you have to go to court against the people, not AB Traders. Why? A Traders as a sole proprietorship, nor AB Traders as a partnership has separate legal personality. The business and the owners are one and the same. If you are going to court, you have to go to court against the owners, not the business. But comparing to this, let's say we'll take a company, right? Three people, A, B and C. Three people, A, B and C. Three people, right? A, B and C. Starts a private limited company called ABC Traders. Starts a private limited company called ABC Traders Private Limited. ABC Traders Private Limited. You buy a chocolate from ABC Traders Private Limited, the chocolate is expired. Against whom will you go to court? Will you go to court against ABC Traders Private Limited, or will you go to court against the persons A, B and C? Here you will have to go to court against the ABC Traders Private Limited. Why? ABC Traders Private Limited is a separate legal person. ABC Traders Private Limited is a separate legal person that is separate from its owners, shareholders, directors. ABC are separate. ABC Traders Private Limited is separate. You have to go to court against ABC Traders Private Limited. Why? ABC Traders Private Limited has a separate legal personality. This is the meaning of separate legal personality. If you have not understood this before, this is the meaning. So when you take a sole proprietorship, the person A, owner A and A Traders one and the same. When you take a partnership, the owners A and B and AB Traders are one and the same. But when you take a company, the owners A, B and C are separate from the company ABC Traders Private Limited. ABC are separate persons. ABC Traders Private Limited is a separate person. This is what we call as separate legal personality. Because of this separate legal personality, companies get a limited liability status. What is this limited liability status? What is this limited liability status? I'll take, for example, I'll erase this part. So we'll take something like this, right? If we take something like, for example, let's take under limited liability, let's say you as a shareholder, let's say A, let's take it as A, right? A person called A buys shares of a company. Let's say each share is worth 100 rupees. Share price, each share is worth 100 rupees, and he buys 10 shares of the company. Meaning he have to spend how much? 1000 rupees to buy the shares of the company, right? His liability is limited to this 1000 rupees. He don't have to spend even a rupee more. His liability is limited to this 1000 rupees and nothing more. That is what we call as limited liability. In case the company collapses, maximum that A will lose is this 1000 rupees. In case if there is unpaid amount of this 1000 rupees, that amount A will have to give. Let's say A have bought 1000 shares worth 1000 rupees, but he have only paid 800. So 200 still he owes to the company. Company at a point of liquidation, company can tell A to come and give this 200 rupees, but company can't ask for anything additionally. Maximum that A will lose on behalf of the company will be 1000 rupees. That's why we say that A or the shareholders will have limited liability. Company doesn't have limited liability. Company have to settle all its debts. Up until the company is declared insolvent or bankrupt, company has to pay all its debts. But when you take the shareholders, they have limited liability. Liability is limited to what? To this amount that they have agreed to contribute, to the amount that they have agreed to contribute, right? That is what we call as limited liability. So another feature is that the shareholders in a company, not everyone, shareholders will have limited liability. Shareholders will have limited liability. Then perpetual succession. What is this perpetual succession? Usually if you take a sole proprietorship or partnership, it will die together with the owner. Sole proprietorship or partnership will die together with the owner, right? Why? Usually the owner is the business, and therefore when the business collapses, when the owner collapses, automatically business will collapse. But the companies, it is not so. Even if the shareholders die or resign, or something happened to them, no problem, still the company will be there. So companies will have perpetual succession. Companies have perpetual succession. The other one is separate property. Company can have property in its own name. Now let's say sole proprietorship, what we discussed earlier. Let's say A starts a sole proprietorship called A Traders. If A Traders is buying, let's say, simply a share, right? The receipt should be issued under the name of the person A, not A Traders. Let's say A and B together starts a partnership called AB Traders, and AB Traders buys a share. The share should be under the name of AB persons, not AB Traders, right? Why? There's nothing called A Traders or AB Traders, no separate personality. They can't have assets of their own, right? But let's say ABC, 3 people starts a private limited company called ABC Traders Private Limited. Now ABC Traders Private Limited buys a share. The receipt should be issued under ABC Traders Private Limited, not the persons A, B and C, right? Not the persons A, B and C. The receipt should be issued under ABC Traders Private Limited. Why? A company can have their own separate property. Owners' properties have nothing to do with the company's properties. Company will have properties under the company name, separate from the owners, shareholders, directors, management. Next one, transferability of shares in a company. Easily you can transfer the shares, right? That's why I told you earlier, when you take a sole tradership, usually automatically sole tradership collapses. The person, owner of the sole tradership collapses, sole tradership also collapses together with the owner, right? But it's not so in a company. Why? There is a feature called transferability of shares. If one shareholder wants to walk out, or if the particular shareholder dies or anything happens, very easily shares will be transferred to someone else, or you can sell your shares to someone else. So easy transferability of shares is a feature of a company, and the capacity to sue and be sued, all of these features are particularly coming from the separate legal personality itself. All these features are bidding from the separate legal personality, as I explained to you earlier using the chocolate example, where you're buying an expired chocolate from A Traders, AB Traders and ABC Traders Private Limited, right? When you're suing, if A Traders, you have to sue if it's a sole tradership, sole proprietorship, you have to sue the owner, person A. AB Traders, if it's a partnership, you have to sue the owners A and B. But in ABC Traders Private Limited, you sue ABC Traders Private Limited, not the owners A, B and C. Why? They are a separate legal personality and they have the capacity to sue and to be sued. They have the capacity to sue and to be sued. That's the reason. So these are the main features of a company. Very, very, very important for you to remember, have been questioned in the past as well. Companies have a separate legal personality. Their shareholders have limited liability. Companies have perpetual succession. Company doesn't give away or absorb with the owner. Separate company can have its own separate property. In a company there is transferability of shares, and companies have the capacity to sue and to be sued. Have the capacity to sue and to be sued. These are the main features of a company. After discussing the features of a company, next we are moving on to discuss about the advantages and the disadvantages of incorporating a company. I mean, is it good to have a company? Of course, everything has advantages and disadvantages. Nothing that we do in companies or in real life is all advantages or all disadvantages. Of course, everything has its own advantages and disadvantages. So first, let's focus on the advantages of incorporating a company. This is also another area where a very creative question can be asked. Why do we say that a very creative question can be asked from this particular area? Because they can give you a scenario, and in the scenario they can say, okay, this particular person wants to, thinking about starting a company. What are the benefits if this person starts a company? What are the demerits of this person starting a company? So those questions can be asked. You need to know the advantages and the disadvantages of incorporating a company. First advantage, independent. Now we are discussing about the advantages. As of now, we are discussing the advantages. Independent corporate existence. So company is on its own, right? It's like, a baby, little by little. Now at the beginning, a baby at the beginning is like a sole proprietorship or a partnership. Always needs attention. You have to always, be around and check what is really happening. But when time goes by little children become independent. Same way, companies are like these adult children, they are independent. So owner don't have to always, take liability, responsibility for the actions of the company, because company is standing on its own. Company takes its own responsibility. No one is liable for anything that happens in the company. Company takes its own responsibility, which is indeed a good thing, right? Which is a good thing. Why? Because owners don't have to be behind it, and owners don't have to bear the liability. We know under the laws of Sri Lanka also, if a child who is below a specific age does something wrong, the parents are responsible. As the guardians, parents are responsible. But then that is a liability on the parents, right? You have to always think, okay, what will the child do wrong? Same way, in a sole proprietorship or partnership, always the owners are the business. Something wrong happens in the business, they become liable. So there are a lot of things for them to focus on. But in a company, no such thing. Once you incorporate the company is on its own, has its own separate legal personality. So that is a good thing or an advantage of incorporating a company. Second advantage, easy to raise capital. When you are doing a sole proprietorship or a partnership, one way is, if you want more capital for the business organization, you have to pocket it out. You have to put it out from your own money in a sole proprietorship or even in a partnership, right? And also, even when you go to take a bank loan or anything, even a loan from a financial institution, they particularly don't like to. Why? They are afraid whether this is stable, whether it will be there for a long time or not, whether it will collapse. They are afraid. So because they are afraid, we have an issue. Because of that, usually they take a lot of time, or they ask for a lot of securities when issuing a loan, or even debentures or whatever it is, right? But on the other hand, when it comes to a company, one easy way to raise capital is they can issue more shares, sell more shares, get more money, especially if it's a company limited by shares, right? You can easily sell your shares and raise more capital. One way. Second way, even when you go to take a loan, right, from a bank or a financial institution, they prefer to give you a loan. Why do they prefer to give you a loan? It's a company, more stability. So people are not afraid to give a loan, right? Just like people are not afraid to invest in company shares. So like that, it's usually easier to raise capital when it's a company, easier to raise capital in a company. Next one, transfer of ownership. Now usually if the in a sole proprietorship or in a partnership, if the ownership is being transferred, the entire business organization have to transfer the ownership, right? Which is not easy. and also there's a long procedure. But when it comes to shares, no problem, right? If I am having shares of company A today, I don't want the shares, I can easily sell the shares to someone else and walk out. Transferability of shares, right? That is also easy. Therefore nothing will happen to the perpetual succession of the company. Company will be surviving, shareholders will be coming and going, no big issue. Next one, limited liability. As I told in the previous slide, the limited liability of the shareholders, right? In a sole proprietorship or a partnership, if the company if the business organization collapses, if a sole proprietorship or a partnership collapses, big problem, right? If can't pay the debts, if can't pay the loans, if can't pay the creditors, sole proprietorship or the partnership's owners will have to pocket it out from their own personal funds. Right? They have to pocket it out from their own money. They can't say, no, it's the business. Now business has collapsed. I also don't have money. You can't say that, right? You have to pocket it out from your own money up until you prove in court that you are bankrupt. But when you take a company, shareholders are having limited liability. As I explained to you before, maximum that the shareholder will lose is the money that he invested in the company, nothing else. Nothing else that the shareholder will lose. Maximum what the shareholder will lose is the money that the shareholder has invested in the company. Even if the company collapses and unable to pay the debts, the creditors can't come behind the personal assets of the owners. So the personal assets of the owner is safe. If at all, if someone claims anything, it should be from what the company has. That's why I told you, company has unlimited liability. Company had to settle all its debts, but the shareholders, owners, directors, they have limited liability. They have limited liability. So of course we all like a situation where we have less liability. Who amongst us like to take all the liability in the world? We all like to have a lesser liability. So same way, when you incorporate a company, liability on you is less. That's another advantage. Next one, enhances the business credibility. Once you incorporate a company, people have this, viewpoint, it's a company, right? Not like a sole proprietorship or a partnership. There is more credibility. Why? Because the incorporation process is there. Now you have to go to lawyers, there are documents to be prepared, people sign sheets. So everything there is, some people who are responsible. But in a sole proprietorship or partnership, there's no person to give that guarantee. So thereby, credibility that even a bank or a financial institution will keep on the stability is less for sole proprietorships and partnerships, more for companies. So your credibility as a business organization increases once you incorporate it as a company. Next one, perpetual existence. Nothing will happen to the company. You have nothing to worry about. Sole proprietorship, partnership usually collapses with the owner. Company, no problem. Company will be there for a longer period of time, or for the foreseeable future, company will be there. So the longevity is there. You have nothing to worry about. That's the perpetual existence. Then the common seal. Now one might say, okay, in a sole proprietorship partnership, for the business and the owner is one and the same. Owners will sign on behalf of the business. No problem. For a company, we have something called a common seal. In a company, we have something called a common seal. So we affix the common seal and the directors or shareholders will sign underneath. So there will be some signing signatories appointed. Signatories will sign under the seal. Usually it's a director and the company secretary. So they will sign saying that this is the company seal. Right, so the round seal of the company, there is a common seal. So that issue is also sorted out, no problem, very easy. Even when you are entering into a contract with a company, no problem. Two directors or director and the company secretary will come with the common seal of the company, place it in front of the notary or the lawyer and sign underneath that this is the seal of our company. So common seal is also there. And a separate management, that's an important point. Usually when you take all the other business organizations, that is sole proprietorships and general partnerships, right? So there's two aspects to a business. There's two aspects called ownership. There is two aspects called ownership and management. There is two aspects called ownership and management, right? Ownership and management. Ownership and management. In sole proprietorships and partnerships, ownership and management is combined together. Owners also manage the company. Owners also manage the company. But when it comes to a company, the ownership and the management is separated. The ownership and the management is separated. Usually, shareholders will be the owners of the company. Shareholders will be the owners of the company, and the directors, board of directors, will be the management, board of directors. So there is a clear separation between ownership and management, usually, unless sometimes in private companies shareholders also become the directors of the company, then they can intervene in the decision making. Usually decision making, especially the day-to-day decision making of the company, happens through the board of directors, and shareholders are having ownership. So there is a clear separation. Everyone knows where they are standing. Owners know where they are standing, board of directors know where they are standing, which is a good principle or a good theory. So therefore, these are the benefits of incorporating a company, starting from the independent corporate existence, the ease of raising capital, transferability of shares, transferability of ownership, thereby limited liability, enhances the business credibility, perpetual existence, common seal, and separate management. Those are the good things or the advantages of starting a company. But as I said before, everything is not advantages, you know, we have some disadvantages as well. Everything is like that. So what are the disadvantages now of incorporating a company? First we discussed the advantages, now the disadvantages of incorporating a company. First one, the most important disadvantage of incorporating a company is the expense. Starting a company is not easy. It is an expensive process. Starting a company is an expensive process. Why do we say that it's an expensive process? Because a lot of money have to be spent on the incorporation procedure. First thing, the government charges. Government charges will depend on the number of directors, number of shareholders. On all of this, the government charges will vary. It's not only the government charges. Usually, incorporation, to do get the incorporation done, either you will go to a management company, a company that does such incorporations, or you will have to get legal expertise or legal services. Those are not cheap, right? Lawyers also charge big amounts to incorporate a company. Government charges also there. So with all of this is an expensive process compared to sole proprietorships and partnerships. Sole proprietorship, partnership, you can go to the closest, you know, the Pradeshiya Sabha or to the divisional secretariat division and get it not incorporated. You can get it registered. Not a hard process, not a very expensive process, only the little bit of the government charges, just one form to fill. But when it comes to incorporation of a company, it is not so. There are some important posts like company secretaries, auditors, directors, shareholders, signatures need to be there, seals need to be there, a lot of procedures. Therefore, it is expensive to begin a business or to begin a company compared to sole proprietorships and partnerships. On the other hand, another very, very important one is the double taxation. In a company, there is double taxation. Why is there double taxation in a company? Now, usually companies are paying a corporation tax, that is on the profit of the company. Company is paying a corporation tax, right? It doesn't stop from the corporation tax. After paying the corporation tax, okay, dividends will be paid to the shareholders. Now, dividend comes to the shareholder as an income. Dividend comes to the shareholder as an income. It's an investment income, no? That is what the shareholder have invested. So the dividend that the shareholder gets is an income. And the shareholder again pays income tax. Company on the profit pays corporation tax. On the distributable profit, dividends are paid to the shareholders. Thereby, shareholders on the dividend are paying income tax. So the same profit is double taxed. What are the two taxes? Corporate tax of the company and the income tax of the shareholder. So it is double tax. But when you take a sole proprietorship or partnership, there is no corporation tax. Sole proprietorships and partnerships, owners will pay their income tax. I mean, of course, they have to register. If they register, they have to pay the income tax. That's it. But when it comes to a company, not only the income tax, not only the income tax that the shareholders pay, even the company pays a corporation tax. So therefore, the particular income, or let's say the profit, is double tax. So double taxation is another disadvantage of a company. Third one, complex procedure. right? Everything in a company, sometimes doing it is difficult. Now earlier I said that transferability of shares is easy. I mean, of course, the concept of transferability is easy, but when you go to the procedure, it's a big procedure. You have to take shares, sometimes you have to enter into a share transfer agreement, share purchase agreements, then how shares are going from one person to another. They have to have a company copy, have to inform the registrar. So many procedures. Even when you are changing the company name, so many things have to be filled in, right? You have to inform the registrar every step of the way. A lot of documentation involved. So therefore, it's a very cumbersome process, right? A lot of documentation involved. And nowadays, because I told you that we have the EROC platform, no, so once you submit everything, it doesn't get approved, right? It takes some time, and also sometimes they reject some of the applications. So then the application should be put anew. So it's sort of a cumbersome process because of the complex procedure. A lot of documentation have to be put in from time to time. Next one, lack of control. The same thing that I told you as an advantage before, the same thing that I told you as an advantage before sometimes ends up being a disadvantage. Why? Earlier, when you take the sole proprietorships and partnership, owners had all the powers. They were the owner and it's their money. They invest the money. They were very, very bothered about the business. They were very, very bothered about what is really happening in the business. Thereby, they paid a lot of attention to what is happening in the business because it's their money. But now came the separation. Now, shareholders' money, but being managed by the board of directors. Shareholders' money, but being managed by the board of directors. Board of directors are not bothered about anything else but their salary. All of us will always think about ourselves first. No, whenever there is a problem, before thinking about anyone else, we always think about ourselves first. So thereby, directors are more bothered about their salary, their bonuses and their increments, and not really bothered about the money that the shareholders have invested. Why? Now ownership and management is separate. In sole proprietorships and partnerships, no problem. Ownership, management, everything is done by one person or two persons or the number of owners. Now it's not like that. Management is separate to ownership. So there's a division of power between shareholders and board of directors. Thereby, sometimes there are corporate governance issues. Directors sometimes don't really think that they have to work in the best interest of the shareholders. And when they do not think so, there are automatic problems under lack of control. Shareholders might sometimes lose control, particularly loses control because of the board of directors. That's another disadvantage of a company. Ongoing paperwork. Paperwork of a company is never ending, right? You think, okay, after incorporating a company, now my job is done, no problem. No, it doesn't end like that. Why? If you do any change to the company, yes, you have to inform the registrar via documentation. Even if you don't do any changes in the company, let's say nothing happens in the company, still the more annual returns have to be filed at the end of the year. If you don't file annual returns, there will be civil liabilities as well as criminal liabilities. So you have to file the annual returns. The particular form should be filled, submitted from time to time. So therefore, that aspect is also there. It's a cumbersome process to maintain the documentation. Ongoing, there's enough and more documentation in a company. Like in a sole proprietorship partnership, you can't think about something now and do it in the next hour. You can't do that. In a company, everything should be pre-planned. Everything should be planned in writing, documented, so that you can inform to the registrar. So the ongoing paperwork can be cumbersome, another disadvantage of a company. Finally, just like it is difficult to incorporate a company, it is also difficult to dissolve a company. Sole proprietorship partnership, you don't want it, close down the market and go home. Easy as that. But when it comes to a company, you can't just close down a business like that, right? Dissolving the company is also a huge process, right? Liquidation is also a huge process. So we are going to study all of these liquidation procedures also later on. So therefore, you can't easily close down a company. Dissolving is also a difficult process. So from the start of the company, sometimes to the end of the company, the documentation in itself is very cumbersome, and that is another disadvantage of a company. So the disadvantages follows as the expenses, double taxation, complex procedure, lack of control, ongoing paperwork, and the difficulty in dissolving. So those are the advantages and the disadvantages of the company. Another important area, because a scenario based question can be asked from this particular area. Even a section 1 question can be asked, but perusing the old past papers, you might also notice that this area is not much questioned in the first part, but section 2 and section 3 questions are possible. That's on the advantages and disadvantages of incorporating a company. Thereby, we are moving on to discuss about corporate legal personality and the separate legal personality. We are going to discuss together with the veil of incorporation. Veil of incorporation comes later on in the tune. We'll start with the separate legal personality. I've explained to you what is separate legal personality already. Meaning of separate legal personality is that the shareholders and the owners are separate from the corporation or the company. They are two separate people that are separated by the veil of incorporation. We will come to the veil of incorporation later. What is separate legal personality? I have explained to you already. The company is distinct and different from its members in the eyes of the law. Now, when you take the law, the company and the members are separate. They are not one and the same. If you study in comparison to sole proprietorships and partnerships, this is easier. In a sole proprietorship, owners and the business is one and the same. In a partnership, owners and the business are one and the same. But in a company, owners and the business are separate. The company is distinct and different from the members in the eyes of the law. It has its own seal and its own name. I told you that company will have their own seal, they will have their own name and their own identity. Assets and liabilities are separate and distinct from those of its members. Company can have its own assets, members have their own assets separately. Company have its own liability, company has unlimited liability, but the shareholders have limited liability. It is capable of owning property. Company can have property in its own name, which sole proprietorships or partnerships cannot. They can incur debts. When you are taking a loan, bank doesn't give the loan under the name of the owners. Bank will give the loan under the name of the company if you are taking a corporate loan, if you are taking a loan on behalf of the company. And they can borrow money, they can employ people. Can have bank accounts. Company can have a bank. You can open up a bank account in the name of the company. You can't open bank accounts in the name of sole proprietorships or partnerships. Basically, you can open a bank account and maintain it as a separate legal liability for companies. Entering into contracts, they can enter into contracts in its own name, can sue and be sued separately. How all of that happen, we have discussed earlier. That's why I told you this corporate legal personality area we have discussed already. Now let's see what are the instances where this concept of corporate personality is applied. In what situations do we use this corporate personality area? A company has the capacity both within and outside Sri Lanka to carry out and undertake any business or activity and to undertake or engage or enter into any transaction subject to the restrictions imposed by the Articles of Association. So companies have something called their constitution. The constitution of a company, later on we are going to discuss about this as well, is called as the Articles of Association, AOA. So Articles of Association will say what the company can and cannot do. Company is only governed under the Articles of Association. Owners can't decide what the company can and cannot do. It's under the Articles of Association. Why? Company is a separate legal personality. Company can do anything both inside and outside Sri Lanka under the regulations put on it under the Articles of Association. If it is okay under the Articles of Association, companies can do anything that they wish. Owners have really no say with regard to that. Of course, the main decision making, because when you take a company, it's not a breathing human being though. So because of that, some decision making can happen through the owners. But company can do any business activity it wishes both inside and outside Sri Lanka if it is allowed under the Articles of Association of the company. Now, this was basically put forward in two cases. Now, when it comes to case laws, in your exam answer scripts, even in the question paper, they particularly say that you have to use case laws, a few facts, not you don't have to write the entirety of the case, a few facts of the case law you need to know and you have to put it in the answer script and do a comparison. How to put it in the answer script I will tell you, but in the notes separately I have added some case laws in areas where case laws have been given in your syllabus, because in some areas there are no case laws given. But with regard to the separate legal personality, one of the most famous cases is this Solomon versus Solomon case and the Lee versus 𝐿𝐸 Farming Limited case. Even this Lee versus 𝐿𝐸 Farming Limited case have been questioned over and over in the past papers. A separate tute I will give you at the end of this revision series, having just in point form the main important case facts. A separate note will be given for all the cases of the entirety of the syllabus with the small case facts that you need to remember with each case, but the most important cases I will discuss in class as well. So this Solomon versus Solomon is a very, very important case when it comes to this corporate legal personality. A case that you can't forget. I'll simply tell the case facts of Solomon versus Solomon. What happened was, earlier Solomon had, this person called Solomon had a sole proprietorship. It was a boots business. He was making these big shoes, the boots, right? It was a sole proprietorship and the business was doing really, really great for Solomon. After some time, Solomon decided to convert his sole proprietorship into a company. Can he do that? Yes, no problem. You can convert a sole proprietorship into a company. So Solomon converted the sole proprietorship into a company, with Solomon having almost 98% of the shares. So Solomon was a majority shareholder. Solomon was having a major amount of shares, plus the remaining shares were held by his family members. So Solomon had almost 98% of the shares. Remaining shares were held by his family members. Now the company was not as successful as his sole proprietorship. As a sole proprietorship, Solomon did really, really well, but the company actually collapsed after some time. Now Solomon had to pay the debts. He was also a secured creditor of the company. So he took his money, whatever the secured creditor level, the amount he ought to take, he took from the company, and he was unable to pay the other creditors. Now the other creditors went to court and said, look here, this is very unreasonable. Why? This is Solomon's sole proprietorship that Solomon converted into a business. Solomon was also a majority shareholder. So therefore, even though Solomon converted this into a business, Solomon was solely responsible. Therefore, now Solomon have to pay our debts from his own personal funds, because this is the same sole proprietorship that was converted to a company. So now Solomon, because of Solomon only the company collapsed, Solomon had to personally pay for our debts from his own personal funds. Now what court on the other hand said was, no, that is wrong. Why? At the end of the day, Solomon incorporated a company. In the company, Solomon is a majority or minority. Solomon is a shareholder. Shareholders have limited liability or unlimited liability, limited liability. So Solomon will also have limited liability only. So therefore, in that case, court stood by Solomon and said, after incorporating a company, Solomon is only a shareholder, company standing on its own. So therefore, Solomon only has limited liability just like any other shareholder. Therefore, Solomon is not personally liable for the debts of the others. That was the finding. Why did court stand for Solomon in that particular case? Because of this corporate legal personality that Solomon's business had. Right? So that's a very chronic case you need to remember. Both Solomon versus Solomon and Lee versus 𝐿𝐸 Farming are two cases you need to remember when it comes to corporate legal personality. So the second situation where corporate personality is applied is where properties of the company do not belong to the owner of the company, right? Owner can't have properties of the company. Owner should have owner's own properties. Company should have the company's own properties, right? So that was also another very, very important case when it comes to this ownership of different assets of the company. Is this case of Mokora versus Northern Assurance. I'll tell you what happened in Mokora versus Northern Assurance as well. Basically what happened in Mokora versus Northern Assurance was, Mokora was having a timber business, if you know, with regard to wood, right? Mokora was having a timber business, and for that purpose, Mokora had a forest. For that purpose, Mokora had a forest. And what happened was Mokora converted his sole proprietorship of the timber business into a company. Mokora also, just like the earlier Solomon's case, Mokora converted his timber business into a company. No problem still. Now he owned the forest. Mokora had a forest under Mokora's name. Now what happened was now forest also he had to give it to the company. So the ownership of the forest changed from Mokora to Mokora's company. Now earlier forest was owned by Mokora. Now Mokora started from the sole proprietorship converted to a company. So the forest also, ownership of the forest was moved to the company. But Mokora continued to pay the insurance. Now this forest was insured against forest fires and whatnot. So but Mokora continued to pay the insurance. What happened was one day through a forest fire, the entire forest got damaged or completely distorted. Now no forest, the Mokora's company, not Mokora, Mokora's company went to ask for the money from the insurance company on behalf of the forest. Insurance company said no, there is a problem. Why? Mokora is separate, forest is owned not by Mokora, forest is owned by the company. So Mokora can't pay insurance for the forest on behalf of the company. No, company should pay the insurance because it is the company's property. You can't insure anyone else's property. You can insure your house, you can insure your car. If at all, if your career is dependent on your voice or your hands and legs or in your beauty, you must be knowing these actors and actresses sometimes, they even insure their, appearance. Right? Why? Because that's their earning source. So you can insure what is yours. You can't insure what is someone else's. Right? So therefore, they said, how is Mokora paying the insurance for the forest when the forest is owned by Mokora's company and not particularly Mokora? Thereby, Mokora lost the case. Right? Why? Mokora insured something which is not Mokora's. Now one might say, then why did the insurance company take money from Mokora? That is what insurance companies do. It's business for them. No, they take the money. But when it comes to a claim, they will check the ownership. And when you check the ownership of the assets, Mokora can't own assets of the company. Company can own its own assets. Right? So that's the case of Mokora versus Northern Assurance Corporation Limited. So these cases you don't have to know with the years and everything, just the name of the case is enough. So Mokora versus Northern Assurance is enough. So those two are instances where this concept of corporate legal personality was used. Now let's see what are the consequences of corporate personality. Right? What are the consequences? What are the things that happen to a company because of corporate legal personality? Again, not rocket science, simply what we discussed before, right? Simply these are the features, or these are what the company gets because of the separate legal personality. Because of this separate legal personality, these are the things. This is the concept, this is where it all starts. These are what the company gets because of the separate legal personality. So it have been put forward again under here just for your reference, but when studying, study it together. So consequences of corporate personality: company will have perpetual succession, that is, company is separate, owners are separate. Even if something happens to the owners, company will survive. Company continues to exist even in the instances of death, even if a shareholder becomes bankrupt, or transfer of ownership interest of a shareholder. Even if a shareholder dies or shareholder goes bankrupt, still the company will be surviving. Company will be surviving. Second one, a company is capable of suing and being sued. Company can sue and be sued. Why? Because company is a separate legal person. It can take legal action to enforce its rights or be sued by others for liabilities owed to them. Right? Others can sue the company as well as company can sue others, which only companies can do. Again, a company can acquire, hold and dispose of property. Company can have their own properties, right? Company can have their own properties. Company can own properties separate from the shareholders because of the corporate legal personality. All of these we have discussed earlier. Just to recap, it can do so in its own name, and the shareholders as owners have no proprietary interest in the company assets, especially with regard to company assets. Remember the case Mokora versus Northern Assurance. It can carry out business, enter into contracts and be bound by obligations. Again, company can enter into contracts under the company's name itself. Why? Because of corporate legal personality or separate legal personality. Shareholders' liability is limited to the amount prescribed in the Companies Act depending on the type of the company. Now, why do we say depending on the type of the company? Not only company. The example I gave you earlier for that 1000 rupees, 10 shares being bought at 100 rupees per share, that was for companies limited by shares. But separately there are companies limited by guarantee as well. Then there are no shares, no. That's why depending on the Companies Act, the liability will be stated. But the shareholders' liability will be limited. Company's liability will be unlimited. Shareholders will have limited liability. Why does shareholders have limited liability? Because they are separate from the company, as the company has separate legal personality. So all the features of a company arise from the separate legal personality, right? Now comes to the next concept, the veil of incorporation. This is the veil of incorporation that we are talking about, right? This is the veil of incorporation. So the company is here, shareholders are here. There is a veil in between them, separating the shareholders from the company. Easiest way to remember this is, think about a stage play. On the stage is the company. What people can see is the company. Behind the stage, you know, there is a background cover or a veil. Backstage only the shareholders, owners, directors, management is there. So the company is separate from the owners, shareholders, management through the corporate veil, right? So simply if you think what is a veil, what does a veil do? A veil covers the face, especially of a bride. Same way, veil, the corporate veil covers the face of the shareholders, owners and directors. What the outside world sees is the company, because there is a corporate veil between the company and the shareholders, owners and the directors. That's the veil of incorporation. A veil concept, a legal concept that separates the personality of a company from the personalities of its shareholders. So personality of the company is here, personality of the shareholders are here. There is a veil in between them. So because of this corporate veil only, company gets the corporate legal personality. Because of the veil, company gets the corporate legal personality. And protects them from being personally liable for the company's debts and other obligations, like shown in the case of Solomon versus Solomon. That's why I discussed the Solomon versus Solomon case earlier with you. Now comes to, you know what the corporate veil does. Corporate veil, particularly most important thing that the corporate veil does is it will separate the personalities of the shareholders from the personality of the corporation, giving the corporation a separate legal corporate personality. But in some very limited specific situations, court might decide to lift the veil of incorporation. Court might decide to lift the veil of incorporation. But remember, this does not happen very commonly, right? Because if this happens very commonly, there is no purpose of us studying about the corporate veil and about the consequences of incorporation and whatnot, right? Therefore, this happens only in very limited situations. But in limited situations, courts can decide to lift the corporate veil, or rather we say pierce the corporate veil, or look through the corporate veil. You can say looking through the corporate veil to see what is happening through the shareholders, because what is shown in the company is the behavior of the shareholders, owners, directors behind the company. So in very limited specific situations, court can lift the corporate veil or pierce the corporate veil to see who is standing behind the corporate veil and doing all these actions. And the lifting of the veil of incorporation I have given you. In some compelling situations, courts have lifted the veil of incorporation and have held that the shareholders may be liable for the acts of the company. Now, very, very important point there to be noticed. Because of the veil of incorporation, right? Because of the veil of incorporation comes limited liability. Because of the veil of incorporation comes limited liability. Because of the veil of incorporation comes limited liability. Then by lifting the veil of incorporation, what will happen to the limited liability? Limited liability will be converted to a unlimited liability. or particularly the shareholders, directors will lose their limited liability status if the veil of incorporation is lifted. When the veil of incorporation is there, it is limited liability. But when the veil of incorporation is lifted, limited liability converts to unlimited liability, and thereby shareholders will be personally liable for the acts of the company if the corporate veil is lifted. So situations where the corporate veil can be lifted, again very important point, highlight and keep, because they have asked this in the past, they will ask again, right? They will again ask these points. So therefore remember what are the situations where the corporate veil can be lifted, because only in very specific circumstances that the corporate veil can be lifted. Therefore what are the situations of lifting the corporate veil is important to notice. First one, when the company has been used as a cover for deliberate wrongdoing, where the company has been used as a cover for deliberate wrongdoing. I'll give you an example. Let's say I am working for a company. My name is Dilani. I am working for a company. My name is Dilani. I am working for a company. Company enters into a contract with me. I'm working for a different company, right? Company enters into a contract with me and says that, okay, even if I leave the company, I can't take the clients of the company and go and leave the company. If I want, I can leave the company, but when leaving, I can't take the clients of the company and go. Fair enough, right? No one should be allowed to take clients of a company and walk out. No. So I have been put this rule that even if I leave, I can't take the clients of the company and go. I have signed the contract and agreed that even if I leave, I won't take the clients. However, after a matter of 2-3 years, I decide to leave the company. And start a similar company of my own. I decide to leave the company and start a similar company of my own. Let's say I start it as Dilani Private Limited. I start a similar company from where I left, right? A similar company, Dilani Private Limited. Now, obligation under the contract that I can't remove clients of the company is with Dilani, is with the person Dilani, right? So, Dilani can't bring about clients. Now, I incorporate a company called Dilani Traders Private Limited. Now, it's a company. Company and me, we are separate, no? Company and me, we are separate. So, no problem. Using this separate legal personality, I pull the clients of the other company using Dilani Private Limited. Why? Who enters into the contract was Dilani. Dilani have personal obligations under the contract, correct? I can't get any clients from the previous company I worked for. But Dilani Private Limited is a separate legal personality. Dilani Private Limited can take the clients from the other company. So thereby, to do this, to breach the law, to breach the contract, I use the aspect of limited liability or use the aspect of separate legal personality. I use the concept of a company, which is illegal. I am trying to, do a wrongdoing by covering behind the company. I am doing a wrongdoing by hiding behind the company. In that situation, the corporate veil of Dilani Private Limited will be lifted to see the Dilani who is doing the illegal act by hiding behind the veil of incorporation. To find the Dilani who is doing the illegal act hiding behind the veil of incorporation. For that purpose, you can lift the corporate veil. So like in the case of Hatton National Bank Limited versus Jayawardena and others. Even if you can't remember some of the case facts, at least remember a part of the case name, because in writing answers is very important. You will be given marks for the case laws that you write. When the number of members fall below the statutory minimum. So let's say number of members, usually shareholders, there should be minimum 2 shareholders in a company. So if that falls below than 2 shareholders, also you can't maintain a company, thereby corporate veil can be lifted to see who is doing the illegal act of maintaining such a company having the number of members below the statutory minimum. If the controlling shareholder uses the company as his agent, or if the corporate body is abused for an unlawful law, improper purpose. So here also actually I am using this company for an improper purpose. I am using the company for an improper purpose, for a purpose I should not have used the company. In those situations, of course, the corporate veil can be lifted. Of course, to prevent fraud. Fraud is illegal. Fraud is criminal, right? In that situation, if someone is doing a fraud by hiding behind the company, especially when it comes to these money laundering offences and things like that, wrongful trading, money laundering, in these situations, court will lift the corporate veil to see who is doing the fraud by hiding behind the company. Like in the case of Jones versus Lipman and another. So at least simply try to remember, at least as Jones case or the Lipman case, at least try to remember case names like that. To determine a company's place of residence for the application of specific statutes such as tax laws. Sometimes to identify what are the laws that are applicable to a particular country, right? Now to look at the, now let's say the laws are applicable, let's say on the nationality of the particular company. So you have to find the nationality of the company. How to find the nationality of the company? Usually you look at the owners. The owner's nationality. Now if I am a Sri Lankan, if I am starting a company in Sri Lanka, usually my company will be a Sri Lankan company. So therefore my nationality automatically goes into the company in a majority of situations. In those situations, corporate veil can be lifted to see who is the owner, what is the owner's nationality, or what are the statutes that are applicable to the owner, thereby to the company. To prevent deliberate evasion of contractual obligations, similar to the example I told you, I have a contractual obligation, I don't want to fulfill the contractual obligation. To evade the contractual obligation, I try to use a company. You are not allowed to do that. Thereby, corporate veil can be lifted to check who is behind the corporate veil. To promote the interest of national security or to ensure conformity with public policy, to ensure conformity with public policy. Now that is something like this. Now let's say you would know, let's say take India and Pakistan. So they are rival countries. They are having fights. Usually you don't do business with your enemy, right? So therefore you have to again find the nationality of a particular. Now let's say India wants to do a business with another company. They want to find out whether that company is a Pakistani company or not. So how to find that out? Usually you look at the owners, the origin company of the owners, thereby find the ownership or the originality or the original country of the particular company. For that purpose also corporate veil can be lifted, not particularly when that for an illegal purpose. Then in that situation, to find the nationality, applicable laws to a particular company, for those purposes also corporate veil can be lifted to identify the nationality or the statutes that are available or statutes that are applicable to the particular company. Legislation sometimes lifts the veil in requiring holding and subsidiary companies to prepare group accounts. Now that's a very, very important one. I'll try to explain it here. Let's say there's a mother company called A. Mother company A has 3 subsidiaries, B, C and D. Has 3 subsidiaries called B, C and D. Now if you take A is a separate legal personality, B is a separate legal personality, C is a separate legal personality, D is a separate legal personality. But sometimes court will look through the corporate veil and make them as one. Especially when it comes to accounting purposes, court can say for them to be considered as one, A, B, C and D to be considered as one in the preparation of accounts, for the preparation of accounting purposes, actually in a way to bring about some level of financial independence, right? In a way to bring some level of financial independence even to B, C and D. Sometimes group financial statements are made. So in making group financial statements, again the veil of incorporation between them, this veil of incorporation between them will have to be pierced. Veil of incorporation between them will have to be pierced, right? So that's also another situation. Case law example is given as DHN Food Distributors Limited versus Tower Hamlets London Borough Council. At least try to remember part of the case name. So several situations where the corporate veil can be lifted we discussed: when the company has been used to cover a deliberate wrongdoing, or when the number of members fall below the statutory minimum, if the controlling shareholder uses the company as his agent or he uses it for an unlawful or improper purpose, when a company is used to do a fraud or to determine the place of residence of a company, then to decide when a company is used to evade contractual obligations, when a national security is questionable and we need to find the nationality of a company, and also sometimes to prepare group accounts. In these situations, corporate veil will be lifted. Again, an important area can be questioned. So that's actually the crux of everything that will be questioned from you. This is the maximum that they will question you under the unique features of a company and corporate personality. That's the maximum that can be questioned. However, I have done an analysis of some past paper questions, related past paper questions I have added in the tube. So the CL4 paper of December 2023, there was a section 1 question. I think it's a section 2 question. It's a mistake, not section 1. It should be a section 2 question. Question number 3, the whole question. Then in December 2022 also they have given a section 3 question. Question 6, only part A is from this lesson. And in July 2022 paper, section 2, question number 4, the entire question is on that asset part, what we discuss about Makara versus Northern Assurance with regard to that case, question number 4. So these past paper discussions we will be doing separately as a comprehensive past paper discussion. These are only this set of slides, these slides and this tube is mainly to focus on the specific areas that will be questioned under features of a company and corporate personality. I am hoping that you would have gotten something out of this particular lecture that we did. Focus on the important areas that I told you to notice on. When we do the past papers, the knowledge will be properly cemented. Make sure that you study along with the slide. Whilst you watch the slide, whilst I explain it, study it along with that, so that when we discuss the past paper questions, it will be properly cemented in your head. Hoping to meet you at the next session. Up until then, goodbye.